100% of FPL is appropriate at this time.
Additional discussion, members. Anything further? Senator Simitian.
Thank you. I think the comments are well noted, but members, let's talk about what the choice is. Not what we wish the choice was, but what the choice is. The federal government has already lifted the ceiling to 400%. So we can say, no thank you. We don't want to authorize counties who are in this program voluntarily to access those funds. The federal authorization will still be in place, and the dollars will be drawn down by New York or Colorado or Kentucky or Nevada. I would rather that California had its fair share of funding, given the fact that the dollars have already been authorized and the formula has been set at the federal level. I would further note that that will allow us, using local funds, to cover children who would otherwise not be covered, and the fact that local folks choose to do this with a federal match will take pressure off the state. For anyone, and Madam President, forgive me here, for anyone who's ever heard the dreaded phrase cost pressure in the Appropriations Committee, this reduces cost pressure on the state because federal funds will be forthcoming to help us get the job done. I would respectfully ask for an aye vote.
Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. Blakeslee. No. Calderon. Aye. Cannella. Aye. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Tedlew. Aye. Carolou. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Simitian. Aye. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. No. Yee. Yee, aye. Berryhill, no.
Call the absent members, please.
Emerson.
All right, then the ayes are 26, noes are 13. The measure passes. And that brings us back to file item 56. Senator Corbett? Senator Corbett, are you going to take up item 56? The Secretary will read.
Senate Bill 175 by Senator Corbett, enacting to public contracts.
Senator Corbett.
Yes. Thank you very much. Members, Senate Bill 175 will grow green jobs by demonstrating California manufacturing technology on our own state property. Senate Bill 175 will ensure that the state places solar panels on state property and that there is a preference for California-made solar panels, panels manufactured right here in California. I think this is a novel concept that taxpayer funds be used to support California manufacturers. I was shocked to learn that the Department of General Services did not even know if the solar panels that have been installed on state property were made in California. And we've identified almost 10 companies that assemble or manufacture solar panels in California. This is a growing business in California, and many companies are deciding to locate in California. California-made panels create important manufacturing jobs in our state and cause significant investment in our communities. The bill has the support of California solar manufacturers, my local Chamber of Commerce, environmental groups, and labor groups. I ask for your aye vote, members.
Discussion, members. Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. Berryhill. Blakeslee. Aye. Calderon. Aye. Cannella. Aye. Corbett.
Aye.
Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. LaMalfa. No. Leno. I. Ted Lieu. I. Carol Lieu. I. Lowenthal. I. Negrete McLeod. I. Padilla. I. Pavley. I. Price. Rubio. I. Runner. No. Semidian. Steinberg. I. Strickland. No. Vargas. I. Walters. No. Wolk. I. Wright. I. Wyland. No. Yee. Yee, aye. Anderson, no. Price, aye.
Call the absent members.
Berryhill. Dutton. No. Emerson. Semidian. Semidian, aye.
Ayes 27, noes 11. The item passes. Members, I'm informed by the Secretary that we will be recessing at about 1:25 for Judiciary and for Rules Committee. There is some lunch available in the lounge, and so I would just suggest maybe if we make a focused effort for the next hour and a half, we can dispense with as many items as we can and tighten up the file for the next couple of days. We are now at file item 57. Senator Corbett, the Secretary will read.
Senate Bill 182 by Senator Corbett, an act relating to judicial appointments.
Senator Corbett.
Thank you very much, Madam President. Senate Bill 182 adds sexual orientation and gender identity and expression to demographic information already collected by the Governor, the State Bar, and an Administrative Office of the Courts. Currently, these officials collect demographic information from judicial applicants, appointees, nominees, candidates, justices, and judges. And this demographic information includes race, gender, and ethnicity. This data is self-reported by the applicant and will continue to be self-reported by the applicant. The bill does not predicate the appointment of judges based on any of these factors, but the bill does give us information so that we can make sure that we have information to make sure we have a fair judiciary and a diverse judiciary. The bill is supported by the California Judges Association, Equality California, the California National Organization of Women, and several other civil rights organizations, and I ask for your aye vote.
Discussion, members? Is there any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. No. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Rubio. Runner. No. Semidian. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Wright. Aye. Wyland. No. Yee. Yee, aye.
Call the absent members.
Correa. Aye. Emerson. Price. Aye. Rubio. Semidian. Aye. Wolk.
Ayes 23, noes 14. The measure passes. Next is file item 58. Senator Hernandez will pass. File item 59. Senator DeSaulnier. The Secretary will read.
Senate Bill 201 by Senator DeSaulnier, an act relating to corporations.
Thank you, Madam President. This particular bill, SB 201, is the result of almost 2 years of work amongst a group of people, particularly people from the business section of the State Bar Association, people who deal with corporate law all the time. It creates a new corporate form so that corporations won't be just driven by the highest return on investment, that they can create another requirement, another goal. They would be required under this law to report, to have a public disclosure annually on both their short-term and long-term effects for this other purpose other than return on investment. and it will require shareholders to know from the beginning of a corporation, or if a corporation were to change to become more flexible for a social purpose, say, or an environmental purpose, that what that purpose is. Unfortunately, in corporate culture in America today, too much is driven around liability of shareholders coming and suing corporate officers or directors vis-a-vis the maximum return on investment. This is a good faith effort to change that culture. It provides the same oversight that traditional corporations have. It allows for flexibility and will put California, continue to have California in the position where venture capitalists who have long-term goals and believe in socially responsible investing will be able to do that. I would ask for your aye vote.
Is there discussion, members? Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. Aye. Berryhill. Aye. Blakesley. Aye. Calderon. Aye. Cannella. Corbett. Correa. Aye. De Leon. DeSaulnier. Aye. Dutton. Aye. Emerson. Evans. Aye. Fuller. Aye. Gaines. Aye. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. Aye. Kehoe.
Aye.
Aye. LaMalfa. Aye. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Simidian. Aye. Steinberg. Aye. Strickland. Aye. Vargas. Aye. Walters. Aye. Wolk. Aye. Wright. Aye. Wyland. Aye. Yee. Yee, aye. Runner, no to aye. Cannella, aye. De Leon, aye.
The roll is 37 ayes and 1 no. The measure passes. Senator Lieu, file item 60. The Secretary will read.
Senate Bill 204 by Senator Lieu, enacting to education governance.
Thank you, Madam President. Several studies in the last 2 decades have criticized California's education governance system and made recommendations for reforms that have yet to be implemented. These findings were reconfirmed in hearings I held last year as chair of the Education Governance Subcommittee. There is broad agreement that the current system is overly complex, ineffective, and lacking in transparency and accountability. As one scholar said, everyone's in charge, and no one is in charge. SB 204 would establish the Superintendent of Public Instruction as the person accountable for education policy and performance. It modifies the role of the Board of Education to be advisory to the governor and specifies that membership of the board be diversified demographically and broadly representative of the education system. The bill passed the Senate Education Committee 7-0 and has had no opposition. When Governor Brown took office, he did not appoint a Secretary of Education. He also appointed new members to the board to create broader representation. SB 204 codifies those actions. I've met with the board president and Superintendent Torlakson and look forward to continuing discussions with all concerned parties. We have a unique opportunity to correct the confusion of our government's structure while capturing permanent cost savings and making the system more accountable, transparent, and accessible. And I ask for your support on the bill.
Is there discussion, members? Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. Calderon. Aye. Cannella. No. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. Evans. Aye. Fuller. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. Kehoe. Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. I. Lowenthal. I. Negrete McLeod. I. Padilla. I. Pavley. I. Price. I. Rubio. I. Runner. No. Semidian. I. Steinberg. I. Strickland. I. Vargas. I. Walters. No. Wolk. I. Wright. I. Wyland. No. Yee. Yee, aye.
Call the absent members.
Blakesley. No. Dutton. No. Emerson. Fuller. No. Huff. No.
That is ayes 26, noes 13. Measure passes. Senator Alquist will take up item 61. The Secretary will read.
Senate Bill 222 by Senator Alquist, enacting to health plans.
Senator Alquist.
Thank you, Madam President and members. Colleagues, I authored SB 222 to provide our constituents with another option to meet the health care mandate that goes into effect in 2014. SB 222 provides local health plans clear statutory authority to form joint ventures to provide health coverage for individual and group health insurance markets, the cost of which will be from special funds paid by the groups that wish to participate. So this is all voluntary. In these tough economic times, Californians need and deserve more options for health care coverage. I respectfully ask for your aye vote.
Is there discussion, members? Any discussion? Seeing none, let's see, can we do it? The Secretary will call the roll.
Alquist. I. Anderson. Berryhill. Blakesley. I. Calderon. I. Canella. Corbett. I. Correa. I. De Leon. I. DeSaulnier. I. Dutton. Emerson. Evans. I. Fuller. No. Gaines. No. Hancock. Harmon. No. Hernandez. I. Huff. No. Kehoe.
Aye.
I. LaMalfa. No. Leno. I. Ted Lieu. I. Carol Lieu. I. Lowenthal. I. Negrete McLeod. I. Padilla. I. Pavley. I. Price. I. Rubio. I. Runner. No. Semidian. Steinberg. I. Strickland. No. Vargas. I. Walters. No. Wolk. I. Wright. I. Wyland. No. Yee.
Call
Yee,
the
aye.
absent members.
Anderson. No. Berryhill. No. Canella. No. Dutton. No. Emerson. Hancock. Aye. Semidian. Semidian, aye.
Ayes 26, noes 13. The measure passes. We're at file item 62. Senator Leno. The Secretary will read.
Senate Bill 223 by Senator Leno, enacting to local government finance.
Senator Leno.
Thank you, Madam President. Colleagues, this bill is about local control and voter determination, very much aligned with the governor's idea of shifting both authority and responsibility to local governments and to voters. It is authorizing legislation. It does just that. It gives county government a tool it does not currently have. It authorizes county boards of supervisors throughout the state of California by a 2/3 majority vote to decide whether or not to let the voters in that county decide whether or not to restore their vehicle license fee anywhere up to the 2% it had historically been at the second half of the 20th century. So again, if your county doesn't want it, it doesn't happen. If your county wants this opportunity to raise some additional revenues to sustain services that are at risk, it would have the opportunity to make that decision and let the voters decide for themselves. I would ask for your aye vote.
Is there discussion, members? Senator Huff.
Hello. Thank you, Madam President. I rise in opposition to this bill. The voters have consistently told us that when it comes to raising taxes, they want to have the highest threshold possible. Including in Prop 26 just recently, the voters once again said for fees that it should be a high standard. What this does is takes the state's responsibility where we have legislative authority on a two-thirds supermajority vote to send this out for a two-thirds vote of the electorate, and it allows us to send it down to the local level. We could end up with a hodgepodge of vehicle license fees around the state, and you'd have to reprogram the state computers to accommodate that. It could be very confusing. I think this is another illustration of the insatiable appetite we have for raising taxes around this building. Part of the problem is it's disguised as a fee, but they collect these taxes and they use it for other things that are not used around cars. If you're going to assess this, then put it back into something that benefits the cars, or transportation, fixing potholes, something like that. But on many different levels, this is just the wrong approach, and I urge a no vote.
Additional testimony, members? Seeing nothing further, Senator Leno, would you like to close?
Certainly. Colleagues, just once again, this raises no one's taxes. This gives authority to counties to use a tool they don't currently have in a time of crisis. The opposition says that we'll have a hodgepodge of different tax rates throughout the state. Well, we allow counties to decide what their own sales tax level will be. The state exists quite equanimically, operates just fine with that difference from county to county. I would ask your aye vote.
Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. No. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Tedlew. Aye. Carolou. Aye. Lowenthal. Aye. Negrete McLeod. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Semidian. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. No. Yee. Yee, aye.
Call the absent members.
Correa. No. Emerson. Negrete McLeod. Semidian. Semidian, aye.
Ayes 23, noes 15, measure passes. File item 63, Senator Wright. The Secretary will read.
Senate Bill 296 by Senator Wright, an act relating to gains.
Senator Wright.
Thank you, Madam President. Members, I rise to present SB 296. I worked on this bill a couple of years ago in this body, and it passed bipartisan. But people were concerned because that iteration of the bill said that there would be a 5-year period for getting off of the list. We distributed earlier, you may have on your desk, an editorial from the LA Times about Orange County. One of the things that I commented about 2 years ago was the fact that this pretty much started in poor neighborhoods, and I said that when it moved into affluent neighborhoods, it would change the drill. One of the things that happens, members, is that when you're placed on a gang injunction list, it's in civil court where you don't have access to public counsel and you have to pay for your own lawyer. Where again, in most poor neighborhoods, if you had $20,000 to be able to hire a lawyer, you wouldn't be on the gang injunction list in the first place. So what this bill does, members, is it doesn't say that you can't use the gang injunction. In fact, I grew up in Los Angeles, and the gang injunctions are actually very effective. But what it does say is that when you institute the injunction, that at the same time you have to put forth the process for someone who may not be a gang member or someone who has not committed a crime during the injunction period to have his name removed. That's one of the issues that became a problem in Orange County. What we did is we looked across the state, members, at what are the best practices at gang injunctions. The best we found was in Ventura County. In Ventura County, they do exactly what's mandated by SB 296. Again, this doesn't prevent you from getting on a gang injunction list. What it simply says is that when you're placed on the list, that the same agency that placed you there in civil court without an attorney, without proof beyond a reasonable doubt, should give you a low-cost way to get your name off the list once it's determined that you've been complying with the injunction as it was written. A lot of people may not be aware, for example, in the Nickerson Gardens housing development that I represent, there are people who commit a crime every time they go home, because most of the people who live in the Nickerson Gardens who are over the age of 18 are already on the injunction list. So in effect, when they go home, they can be arrested for being at home. We're going to have to do a lot more work in this area, members. I submit that this is a very modest step taken from best practices in Ventura and in the city of Los Angeles that now institute this. And I would submit that if we're not able to do this, what you saw in Orange County could very well be coming, and we could unravel a very effective tool. This is a modest attempt to put some humanity in a process whereby we take away First Amendment rights of people without the full court authority, and I'd ask for an aye vote.
Discussion, members. Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. No. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. Kehoe.
Aye.
Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Semidian. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Wright. Aye. Wyland. No. Yee.
Call
Yee,
the
aye.
absent members.
Correa. No. Emerson. Huff. No. Semidian. Aye. Wolk.
Ayes 23, noes 15. The measure passes. Welcome to John Benoit. Welcome back, Senator, former Senator. Ms. Runner's engaged in conversation. Mr. Benoit, we want to say hi. Members, Senator Wright, you've got 64 as well. The Secretary will read.
Senate Bill 320 by Senator Wright, enacting to public social services.
Members, this bill has no opposition, so it's a little less complicated. It simply clarifies the process for hearings in a welfare proceeding. In some instances, people are unable to get to the county seat where the hearing is often held. This provides that in some instances you can do the hearing by telephone or alternate means. We have worked with the welfare directors and the judicial people who are involved in these hearings to clarify that you don't always have to go to the home. It has become a lot less onerous. There's not much more cost. It doesn't increase your ability to have welfare. There are a number of hearings that take place with administrative law judges on a daily basis. This provides some humanity to that process. Again, there's no additional cost. It doesn't change the rules of evidence relative to the hearing. It changes the procedure and makes the process more available. Oftentimes, there are people who are handicapped, who are unable to travel to, say, downtown Los Angeles if they lived in Compton where the hearing would be placed. This simply says that you can arrange for alternate means of having the hearing, doesn't change the rules of evidence, doesn't give them any additional rights, nor does it give them any additional welfare. It's a hearing process to make it equitable to all involved. I'd ask for an aye vote.
Is there discussion, members? Is there objection to a unanimous roll call? Then we'll call the roll.
Alquist. Aye. Anderson. No. Berryhill. Aye. Blakesley. Aye. Calderon. Aye. Canella. I. Corbett. I. Correa. I. De Leon.
De Leon.
I. DeSaulnier. I. Dutton. Emerson. Evans. I. Fuller. Gaines. Hancock. I. Harmon. Hernandez. I. Huff. No. Kehoe.
Aye.
I. Lamalfa. No. Leno. I. Ted Lieu. I. Carol Lieu. I. Lowenthal. I. Negrete McLeod. I. Padilla. I. Pavley. I. Price. I. Rubio. I. Runner. No. Semidian. I. Steinberg. Strickland. Strickland, I. Vargas. I. Walters. No. Wolk. I. Wright. I. Wyland. I. Yee. Yee, I.
Call the absent members.
Dutton. No. Emerson. Fuller. No. Gaines. I. Harmon. I. Steinberg.
Ayes 31, noes 7. The measure passes. Next is file item 65, Senator DeSaulnier, and the secretary will read.
Senate Bill 334 by Senator DeSaulnier, enacting to elections.
Senator?
Thank you, Madam President. This bill, members, is one of a number of attempts by members to try to make the initiative system work better for Californians in this day and age. This particular bill just says that an initiative would be required to support in the voters' pamphlet as of 110 days out from the election the 5 largest contributors of over $50,000 in support or opposed to an initiative. This would allow Californians who are thoughtful and read their voters' pamphlet to be aware of, irregardless of ideological perspective, who is funding basically to get the signatures to put it on the ballot. As Senator Hancock mentioned earlier today, there hasn't been a successful volunteer effort to put an initiative on the ballot since 1982. This just provides more information to make the initiative system work better for average Californians. We appreciate the work we've had with the Secretary of State who sponsors this bill and would ask for your aye vote.
Any discussion, members? Senator Lamalfa.
Thank you, Madam President. I rise in opposition to the bill. This somehow would impugn people that are contributors to these types of campaigns is the implication here as well. There's ways to get around it by staying at $49,999 or doing it within the last 110-day window or whatever it is. So, again, this is more of a reflection on limiting people from being involved in the initiative process. I ask for your no vote.
Additional testimony? Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. Calderon. Aye. Canella. No. Corbett. Aye. Correa. De Leon. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. Lamalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Semidian. Steinberg. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Wyland. No. Yee. Yee, aye.
Call the absent members.
Blakesley. Correa. Aye. De Leon. De Leon, aye. Emerson. Gaines. No. Blakesley, no. Semidian. Steinberg. Wright.
Ayes 22, noes 14. The measure passes. Next is file item 66, Senator Negrete McLeod, and the secretary will read.
Senate Bill 350 by Senator Negrete McLeod, enacting to the Public Employees Retirement System.
Thank you, Madam President and members. SB 350 makes changes to the 1959 survivor benefits at CalPERS. This benefit applies to local agency CalPERS members who died prior to retirement. These public employees do not have Social Security, and this benefit is meant to take place of Social Security benefits for their survivors. Current law requires employees to contribute to these benefits even when they are fully funded. Because these benefits are rarely used, the lowest 3 levels of the benefit have large funding pools that have accumulated over the years due to the continuous flow of employee money. These benefits funding pools have been superfunded for years, eliminating costs to employers. Combining the 2 lowest levels of the 1959 survivor benefit into level 3 will provide very modest increases to survivors currently in levels 1 and 2, and further protects all participating employers from having to make employer contributions. This bill also ensures that employee contributions to level 3 will kick in any time the funding drops below 200%. This ensures that the program will continue to be fully funded by employee contributions. I respectfully ask for your aye vote.
Is there questions or discussion, members? Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Cannella. No. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. Lamalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Semidian. Aye. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. No. Yee. Yee. Aye. Full House.
Call the absent members.
Emerson.
Ayes 25, noes 14, measure passes. Next item is 67, Senator Corbett. Secretary will read.
Senate Bill 405 by Senator Corbett, enacting to judges.
Thank you very much, Madam President. Senate Bill 405 ratifies the authority of the Judicial Council to convert up to 10 subordinate judicial officer positions to judicial positions. Judges converted from subordinate judicial officers will be tasked with family law or juvenile law assignments previously presided over by a subordinate judicial officer. While California's population has grown by more than 33%, the number of trial judges has only grown by 8.5% to meet demands. Family law and juvenile law cases are among the court's most sensitive and often most complex cases and should be handled by judges. The Judicial Council is the sponsor, and the Family Law section of the State Bar of California is in support of this bill. There's no opposition, and I ask for your aye vote.
Is there discussion, members? Any discussion? And can we use the unanimous roll call? Call the roll.
Alquist. Aye. Anderson. No. Berryhill. Aye. Blakesley. No. Calderon. Aye. Cannella. No. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe. Aye. Lamalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. I, Negrete McLeod. Padilla. I, Pavley. I, Price. I, Rubio. I, Runner. Smidian. Steinberg. Strickland. No. Vargas. I, Walters. No. Wolk. I, Wright. I, Wyland. No. Yee.
Call the absent members.
Yee, aye. Negrete McLeod, aye. Correa. Aye. Emerson. Runner. Smidian. Aye. Steinberg.
Ayes 25, noes 12. The measure passes. File item 68 we pass on. File item 69, Senator DeSaulnier. The Secretary will read.
Senate Bill 429 by Senator DeSaulnier, enacting to before and after school programs.
Senator DeSaulnier.
Thank you, Madam President. This bill, SB 429, allows for greater flexibility for summer and after-school programs for both federal and state funding. Because of the economy, districts have had to close down some of their sites. This allows for some of those sites where kids can no longer have access to actually get through the grantee process access to other sites. There is no opposition. It's sponsored by the Superintendent of Public Instruction, former Senator Tom Torlakson. I would ask for your aye vote.
Discussion, members? Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. Calderon. Aye. Canella. No. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. Aye. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. Lamalfa. Leno. Aye. Tedlu. Aye. Carolu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Smidian. Steinberg. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. No. Yee.
Call
Yee,
the
aye.
absent members.
Blakesley. Aye. Emerson. Lamalfa. No. Smidian. Steinberg.
Ayes 25, noes 12. Measure passes. Members, I've been asked to clarify we will be recessing at 1:30 for rules first, followed by judiciary, resuming session around 2:30. So we'll continue on the file. We are at file item 70. Senator Pavley, ready to take that up? The Secretary will read.
Senate Bill 449 by Senator Pavley, enacting to state government.
Senator Pavley.
Yes, thank you very much. Members, Senate Bill 449 is sponsored by the State Controller and is part of a bipartisan package of 5 bills aimed at preventing local government insolvency before it reaches a crisis point. This bill establishes the conditions and the criteria under which the State Controller would be authorized to conduct a preliminary review or an audit of a local government's fiscal stability. Secondarily, this bill also creates a multidisciplinary local agency financial review committee comprised of the staff from the Controller's Office, the State Treasurer's Office, and the Department of Finance, which would be authorized to provide assistance and recommendations to the local government entity. This is sort of modeled after, for those of you involved in school boards and things like that, modeled after FCMAC, which helps school districts out of insolvency. We don't want cities to reach a crisis point like we've recently seen in Bell and Vallejo. This is a preventative measure. I wanted to let some of you know who are concerned related to costs and appropriations. This bill was amended to ensure that the Controller is only authorized to conduct oversight pursuant to this bill if funding is available. I ask for your aye vote on this important measure.
Is there discussion, members? Any discussion? Seeing none, the Secretary. Senator Anderson, excuse me, I didn't see your mic.
I have a quick question for the senator.
Senator Pavley, will you take a question from Senator Anderson?
I'd be glad to.
Senator Anderson, go ahead.
Would this bill, how would it address the city of Bell or the city of Vernon? Would it help solve either one of those problems?
It's mostly a going forward now, authorizing. There was inability of the Comptroller's Office to be able to engage even voluntarily in some of these cities. So this is a preventative measure which allow under certain circumstances, there's 4 different criteria you could meet or conditions, to go in there, conduct a preliminary review, and if warranted, then an audit. And then what happens is this fiscal committee made up of the finance department, et cetera, and Comptroller's Office could get directly engaged, but they offer recommendations. They don't have the authority to make someone to do something, but most of these cities are floundering, and some very thoughtful fiscal oversight could be in everyone's best interest, including the taxpayers of that city.
Thank you.
Anything further, members? Senator Blakesley.
Thank you, Madam President Pro Tem. I'd like to rise in support of this measure. California's bankruptcy approach toward municipal bankruptcy is a very weak one, which essentially leaves each jurisdiction to make its own decisions whether or not to enter into bankruptcy with a small role, a negligible role for the state. There are certain benefits to that in that those costs are not transferred to state taxpayers. However, there are also certain costs in that the bankruptcy of one jurisdiction or municipality oftentimes affects the credit rating and the investment desirability of the municipalities, the munis that are offered by other cities and jurisdictions. This, I think, is a reasonable approach to provide state oversight, auditing, and investigation of the finances of these jurisdictions in a way that will protect other jurisdictions. So I would urge an aye vote on this measure.
Thank you, Senator Blakesley. Anything further, members? Anything further? Senator Pavley, would you like to close?
Absolutely. I want to thank Senator Blakesley in particular for those comments on the impact of local government insolvency or potentially bankruptcy. Get saddled with increasing borrowing costs and reduced services. Again, this is in the best interest of the city who is trying to avoid a crisis, and the state as a whole. I ask for your aye vote.
Secretary will call the roll.
Alquist. Aye. Anderson. Aye. Berryhill. Blakesley. Aye. Calderon. Aye. Canilla. No. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. Lamalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Semidian. Steinberg. Strickland. Aye. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. Aye. Yee. Yee, aye.
Call the absent members.
Berryhill. No. Emerson. Gaines. Aye. Semidian. Aye. Steinberg.
Ayes 29, noes 9. The measure passes. Next item is 71, Senator Calderon, and the Secretary will read.
Senate Bill 457 by Senator Calderon, enacting to workers' compensation.
Senator Calderon.
Thank you, Madam President. Members, SB 457 addresses a loophole which leaves medical providers unreimbursed for care actually given. As such, SB 457 is fair and fits well with the efforts of hospitals to control excess costs. It'll stop workers' comp third-party administrators from denying full payment for care that a health plan actually provided to a worker on a self-procured basis before the injury was found to be work-related. SB 457 helps heal the health insurers recover in full for a worker's treatment. This will speed the resolution of disputed claims and hasten the worker's return to work, which is the ultimate goal. I ask for your aye vote.
Any discussion, members? Any discussion? Seeing none, the Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. No. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Tedlew. Aye. Carolou. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. No. Semidian. Aye. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. Aye. Yee. Yee. Aye.
Call the absent members.
Correa. Emerson.
The ayes are 25, noes are 13.
Correa, no.
Ayes are 25, noes are 14. The measure passes. Next is file item 72, Senator Rubio. The Secretary will read.
Senate Bill 497 by Senator Rubio, an act relating to public contracts.
Senator Rubio.
Thank you, Madam President. And members, California, as you know, currently has an unemployment rate that's unacceptable at just under 12%. Having the honor to serve Kings, Kern, Fresno, and Tulare County, unfortunately, I can tell you that I have 10 communities that have an unemployment rate of over 40%. That's 40. Nearly 1 in 2 people are unemployed in 10 communities that I have the honor of representing. SB 497 would simply give eligible California businesses a 5% preference in the competitive bid process for contracts with the state. To be eligible, a company must meet 2 requirements. First, directly provide goods for the contract from its principal place of business within California. And second, certify that 90% of its employees that will be working on the contract are residents of this fine state. Members, small businesses that span this great state of ours is the backbone to our economic recovery. The Small Business Association supports this bill. I respectfully ask that you support this bill as well. Thank you very much.
Discussion. Senator LaMalfa.
Thank you, Madam President. I want to like this bill, and the previous one like that had the 5% reference in it. But why don't we instead attack the problems of California that cause costs of business to be so much higher here, instead of having to find a 5% allowance for those businesses that are here? Let's reward businesses that want to be here by giving them the atmosphere to desire to be here and to be able to compete and stay in the state. So I can't get excited about this bill or the previous one, because it continues to foster the atmosphere of being an anti-business state. So I ask for a no vote.
Further discussion, members. Anything further? Senator Rubio, would you like to close?
I appreciate my dear friend Senator LaMalfa's comments, and believe me, we are moving forward with some bills that are going to try to reverse that trend. But until then, I believe this is an important measure, and I'd respectfully ask for your aye vote.
The Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. Calderon. Aye. Canella. Aye. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Tedlew. I, Carol Liu. I, Lowenthal. I, Negrete McLeod. I, Padilla. I, Pavley. I, Price. I, Rubio. I, Runner. No. Smidian. I, Steinberg. I, Strickland. No. Vargas. I, Walters. Wolk. I, Wright. I, Wyland. No. Yee. Yee, aye. Walters, no. Blakesley, aye.
All righty. The vote is 27 ayes, 12 noes. The measure passes. Next is file item 73. Senator Lowenthal. The secretary will read.
Senate Bill 517 by Senator Lowenthal, enacting the high-speed rail.
Senator Lowenthal.
Thank you, Madam President. Members. SB 517 is the result of 9 oversight hearings of the High-Speed Rail Authority, which were held over the past 3 years by the Senate's Transportation and Housing Committee. We learned that the high-speed rail project is the most technically complicated surface transportation technology that can be deployed. It's complicated to construct, it's complicated to finance, and it's complicated to incorporate within existing communities. This requires board members familiar with these issues to provide informed policy direction to the project's executive director and staff. Further, the existing board is not subject to Senate confirmation, so we as senators do not have the opportunity to vet the qualifications of the board members. Another finding is that the authority is not within the organizational framework of state government. It's not directly accountable to the governor nor to his appointees. Specifically, SB 517 does the following. 1, it requires the board members to have specific skills such as engineering, legal, environmental, finance, and the like. Placing technically knowledgeable people on the board is not unusual. We do that for other boards. 2, it makes 5 appointees of the governors be subject to Senate confirmation. It places the authority in the Business, Transportation, and Housing Agency and appoints the secretary of the agency as a non-voting ex officio member of the board. In addition, all the existing appointees' terms expire next year, and new members shall be appointed to meet the requirements of this bill. I respectfully ask for an aye vote.
Discussion, members. Senator Yee.
Thank you very much, Madam President. Senators, let me commend the good work of Senator Lowenthal. When I also served on the Senate Transportation Committee, it was rather outrageous by the actions of the High-Speed Authority, where the voters had really clarified not only once but several times that we, in fact, wanted to have a high-speed rail that would connect Southern California and Northern California, and that the Transbay Terminal was, in fact, the destination point. And what we found was that the High-Speed Authority on their own decided that, well, I don't care what the voters said, we're going to do whatever we want to do. And they squander and they wasted quite a bit of money in terms of looking at alternatives. If that is the case, then you wonder why people in general don't trust the electoral process and what they vote for. I think that this bill is extremely important because it will bring back some integrity to the process and bring back some confidence that the voter for the voters that what they vote for is exactly what they're going to get. So with that, again, thank you very much, Senator Lowenthal, for your good work.
Thank you. Senator LaMalfa.
Thank you, Madam President. I stand in support of this bill. Anything would be better than what we have right now governing the High-Speed Rail Authority. Anything would be an improvement over an authority that has really no business plan, no idea where they want to route this railroad, no idea what it's going to cost, no idea who's going to ride it, how many people will ride it. It's a disaster. So this would be a good opportunity via Senator Lowenthal's bill to call timeout, put some people on the board that actually have an idea of how to build a railroad, how to run a business, and I would also ask that this body consider in the very short term not expending a single new dollar, whether these federal dollars that are coming through or our own bond dollars via Prop 1A, until we have a business plan, until we know where we're even going to put the railroad and whose land is going to be affected, what the people of the South Bay area think, what the people of the Valley think about where it's going to route through their lands, and not spend nearly $1 billion per year servicing the bond debt when we don't easily find $1 billion around here to take care of things like law enforcement and sheriffs and schools and some of these things that we're having to cut in order to get through this mess of a budget. Why in the world is this still a priority is beyond my type of thinking. So I support this measure that Senator Lowenthal is moving forward as one small step towards what we need to do in reassessing the high-speed rail system in California as its viability, as its cost effectiveness. I ask for your aye vote.
Senator Gaines.
Thank you, Madam President. I'm really troubled by what's happening with high-speed rail here in California. And when we look at the editorial that was in the Wall Street Journal yesterday that highlighted the massive amount of federal spending in the Central Valley for which is probably the least viable portion of high-speed rail in the state of California, I'm very disturbed. I think we're going down the wrong path and that we ought to be looking at higher concentrated levels of density in the state. We ought to be looking at Sacramento to San Francisco routes. We ought to be looking at LA to San Diego routes. We ought to be looking at existing technology with trains that could go to 125 miles an hour. That would greatly reduce the cost of high-speed rail. We ought to live within our means of the initial initiative at $10 billion, and we ought to be very careful about expending any of those dollars in the near future, given the current fiscal mess that we're in. So I've got grave concerns. I do appreciate Senator Lowenthal and his willingness to try to start fresh, but I think it's based on the wrong assumptions because this could turn into a huge boondoggle if we don't rein it in. So I'm going to have to be opposed to the senator's legislation. Thank you.
Senator Steinberg.
Thank you very much, Madam President. I rise for several reasons. Number one, I want to commend Senator Lowenthal for trying to mend it, not end it, as a former president once said. This is the right step. You know, what's really happened with high-speed rail is that for years before the ballot measure passed, it was a very small organization that was focused on the preliminary work to try to put this measure before the people. And the people, let's not forget, said yes, they want this investment, and they want this investment because it's probably the only chance we have in this state to make a big impact in improving air quality, in moving people more efficiently from population centers in this state. And it also has the potential to create the single greatest public works project, you talk about infrastructure, in the history of this state. And the people said yes. The federal government has said California is far ahead of the nation's curve here, and they've awarded us $3.5 billion. And given what other states are doing, there may be more. And so I want to just make it very clear publicly, while I have concerns about the governance and about the staffing issues and about some of the things that motivate Senator Lowenthal's bill, I want to send a signal as leader of this House to the federal government and private sector partners that California is in. We want this to work. And this bill and these reforms will help give people the confidence that we can finish this project. I urge an aye vote.
Senator Rubio.
Thank you very much, Madam President. And that's a great segue in sending that message to the federal government as to which leg of the high-speed rail is the most viable, and I would respectfully disagree with Senator Bates that the Central Valley leg is not viable. Let me put it very simply. You only get high-speed rail in the Central Valley. If you do not build it in the Central Valley, you do not have high-speed rail. And so when we build it, it should be built in the Central Valley so that we can say that in the United States of America, we have finally accomplished the goal in reaching high-speed rail and building it there. I know this bill doesn't touch on where to build it, but I wanted to make sure for the record we commented on what's viable and not. Thank you very much.
Senator Correa.
Thank you, members. Just to be brief, those federal dollars have an expiration date. High-speed rail is doing its work. It needs accountability measures. Clearly, this is a strong step in that direction. Let's get Californians back to work and get some accountability here. Ask for an aye vote.
Any further discussion, members? Then Senator Lowenthal, you may close.
I think we've had a good discussion. I think that the message in this bill is we've now done a great deal of oversight. This will make it work. Let's make sure that we have high-speed rail that works. I urge an aye vote.
Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. No. Corbett. Aye. Correa. De Leon. DeSaulnier. Aye. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. Aye. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. Aye. Leno. Aye. Tedlew. Aye. Carol Liu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Runner. No. Smidian. Aye. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Aye. Wright. Aye. Wyland. No. Yee. Yee. Aye.
Call the absent members.
Correa. Aye. De Leon. Aye. Emerson. Rubio.
The ayes are 26, noes 12. The measure passes. Senator Steinberg, are you ready to take up item 74?
Yes, I am. Thank
Secretary will read.
Senate Bill 547 by Senator Steinberg, an act relating to school accountability.
Thank you very much, Madam President. If our system of public school accountability has taught us anything, it's this. What gets measured is what in fact gets done. To date, we have the Academic Performance Index, and parents and teachers and anyone involved in education knows about the API and the annual rite of spring, the testing and the test scores. The API has measured one thing: test scores that are done on a multiple choice basis by putting a little prick in a bubble, A, B, C, or D. The simple fact that testing has become the definition of school performance has inarguably narrowed the curriculum, stifled creativity, and may have prevented us from reducing the unacceptably high rate of dropouts from our middle and high schools. Standardized tests are important, and this bill does not seek to get rid of standardized tests. But I think we must acknowledge they don't tell us everything. This bill changes what gets measured by broadening the index at the high school level by adding measures of student preparedness for college and career. It does the following: reduces the proportion of the API for high schools that it is devoted to standardized tests from 100% to 40%. It directs the superintendent of public instruction and the Board of Education by 2014 to change the index to reflect college and career readiness, and it suggests a menu of possible indices to measure college and career readiness. The bill is supported by the California Manufacturers and Technology Association, the LA Area Chamber of Commerce, and the University of California. It is, members, a work in progress because we want to make sure that we get this right. But if you acknowledge that there is an insufficient connection between public education and economic development and our economy, we have to look at the accountability system and move it in a way that reflects whether or not our schools are actually educating and preparing young people for the workforce. I urge an aye vote.
Discussion, members. Senator Blakesley.
Thank you, Madam President. I appreciate the opportunity to speak on this bill. I have grave concerns when we dumb down our standards in California. We have a duty to make sure our schools perform at the highest possible level and to include criteria that will judge a school based on, for example, whether or not its graduate has secured employment that offers paid sick leave, paid vacation leave, and employer-provided health benefits, really does not speak to the underlying duty our schools have responsibility over, direct responsibility over. I would suggest this is exactly the wrong time to go to weaken our standards at a time when we're seeing a terrible difficulty with performance in our schools, and to now try to hold schools accountable for metrics for which they are not directly responsible, I think misses the underlying point of what teachers can and cannot do. This is a burden that we'll be putting on our school boards, our administrators, our teachers, and ultimately our students that will not benefit education in our state. I advise a no vote.
Additional discussion, members? Senator Steinberg, you may close. Oh, Senator Weiland, I'm sorry, I didn't see it.
Madam President, members, I can't support this today, but I think, and I'd like to see it when it comes back. And I have some suggestions, because I think the API doesn't do the job. No one knows what it means. You can't ask a single parent what it means. It doesn't include things that it ought to include. Unfortunately, we need more CTE, which would lead to higher graduation rates. But a lot of those graduates who could go on to good jobs wouldn't necessarily get high scores that lead to higher API. So there are a lot of problems with it, and I appreciate the fact that the Pro Tem has worked on this, and I'd like to see it as it progresses, and I have some ideas you might want to incorporate. Thank you.
Anything further, members? Anyone else? Senator Steinberg, would you care to close?
Urge an aye vote on what I think is a far-reaching measure that has the potential to change what we teach and the way we teach it in ways that are much more connected to California's 21st century economy. Urge an aye vote.
Secretary will call the roll.
Alquist? Aye. Anderson? No. Berryhill? No. Blakesley? No. Calderon? Canella? No. Corbett? Aye. Correa? De Leon? Aye. DeSaulnier? Aye. Dutton? No. Emerson? Evans? Aye. Fuller? No. Gaines? No. Hancock? Aye. Harmon? No. Hernandez? Aye. Huff? No. Kehoe? Aye. LaMalfa? No. Leno? Aye. Tedlew? Aye. Carolou? Aye. Lowenthal? Aye. Negrete McLeod? Aye. Padilla? Aye. Pavley? Aye. Price? Aye. Rubio? Aye. Runner? No. Semidian? Aye. Steinberg? Aye. Strickland? No. Vargas? Aye. Walters? No. Wolk? Aye. Wright? Aye. Weiland? No. Yee.
Call the absent members.
Calderon, aye. Correa, aye. Emerson, Yee. Yee, aye.
Ayes 25, noes 14. Measure passes. Senator Padilla, for what purpose do you rise?
For purposes of an introduction.
Go right ahead.
Thank you, Madam President. Colleagues, I'll call your attention to the gallery above and ask you to help me welcome visiting fourth graders from the Hollywood Schoolhouse who are on their trip to Sacramento, learning about the history of our state. And I want to call special attention to the governor of the class, the Honorable Finn Slingerland. Thank you for visiting.
Welcome, students. Welcome. We will go now to file item 75. Senator Simitian, the Secretary will read.
Senate Bill 558 by Senator Simitian, enacting to public social services.
Thank you, Madam President and members. Members, there are few populations who are as vulnerable as our elder and dependent adults. That's why we have the Elder Abuse Act in law to protect that particular population. The difficulty is that these cases can be very difficult to prove because when there is a case of abuse or neglect, the person who has been abused or neglected is, by definition, often unable to help themselves or participate in making their own case. Similarly, there are relatively few witnesses around in most circumstances who can serve as a resource. And in an institutional setting, it can be further complicated by the fact that if there are witnesses, they are employees of the institutional setting, which limits their ability to step forward without consequences. This bill does one thing. It changes the burden of proof necessary to make a case under the Elder Abuse Act from clear and convincing evidence to preponderance of evidence. It still retains the very high standard, members, that not only must a successful action provide proof that there has in fact been abuse or neglect, but it has the further very high standard that the case will only proceed if, in fact, it can also be proved that the defendant has been guilty of recklessness, oppression, fraud, or malice in the commission of this abuse. So in order to bring successful suit, you would have to prove not one, but two things by the preponderance of evidence: the fact that there was, in fact, abuse or neglect, the fact that it was, in fact, committed with recklessness, oppression, fraud, or malice. That is the bill. It is a bill necessary both to provide a deterrent to bad behavior, which unfortunately happens all too often, and also to provide a modicum of justice after the fact for people who have been the victims of abuse or neglect. Supported by law enforcement, county welfare directors, and a myriad of senior groups, I would respectfully ask for an aye vote.
Discussion, members. Senator Harman.
Thank you, Madam President. I rise in opposition to this bill. No one wants to inhibit civil actions in elder abuse cases, but I'm not convinced, members, that this bill is necessary in order for those types of cases to be pursued. Now, Mr. Simitian did indicate that it changes the standard of proof in these types of cases from clear and convincing, which is a higher standard of proof, to what I believe is a lower standard of proof, preponderance of evidence. This bill clearly tilts the playing field in favor of plaintiffs' attorneys. And believe me, there's plenty of them that are out there that want to sue nursing facilities because they're ideal targets, in their opinion, to try and pick the pockets of the owners of those facilities. It is absolutely an end run around MICRA, which has been on the books for many, many years and has been very successful in capping medical expenses that are incurred by consumers and keeping medical costs under control. The provisions of this bill apply broadly to any institution, public or private, or individual in the business of providing any type of medical or custodial care for elder or dependent adults. So it's not just, a very limited number of institutions or organizations that are targeted by the bill, but it is practically everyone. I can absolutely guarantee you it will trigger a flood of unnecessary lawsuits and litigation. It will absolutely raise the cost of nursing home care in particular, and probably most other medical care. I strongly urge a no vote.
Further discussion, members? Anyone else? Senator Wright.
I rise, and I've been toying with this bill for a while, and I want to support it today, but I think we need to do another element to it, which is at some point, if it moves forward, there should probably be some level of cap on the amount of the lawsuit that goes forward. The thing I don't think you want to do is create a situation where it's kind of open season on people who are involved in a particular business. I think Senator Harman raised the issue of MICRA, and I'm not sure what the number ought to be, but I think that there ought to be, for those individuals who are engaged in this business, who often have people who work for them, who work for somebody else, so there may be 2 or 3 degrees of separation between the owner of the facility who will get sued and their employee who may have committed the offense, that there ought to be some level that his insurance company and that owner know is the amount of exposure that they have in terms of working. So I think that Senator Simitian has identified a problem that needs some redress. We have some 1,000 agents in California who inspect these facilities, but I would hope if it moves forward that there is some level of certainty where we say that you're liable for this much money per incident or something like that, so that we don't create a situation where we virtually drive the people who are in this business out of this business. Some of you may recall that one of the things that we were experiencing before MICRA is that we were losing doctors at a rapid rate because they simply couldn't afford the insurance coverage. I would hope that we don't create another kind of run where people say it's too expensive to be in the nursing home business in California, and they leave, because at that point, even though we would have good lawsuits, there'd be nobody left to sue. So I hope that we balance the exposure that we make and recognize that there is a problem with elder abuse in California.
Thank you. Further discussion, Senator Gaines. Oh, no, okay. Anyone else? Senator Simitian, would you care to close?
Thank you, Madam President and members. Members, let me respond to a couple of the issues that have been raised. First, the issue of MICRA. The bill does not affect MICRA. Those of you who have long memories and who can look back to 1975 will recall that MICRA is a set of protections that is embedded in the California Civil Code. That's where MICRA is. There are some incidental provisions in the Code of Civil Procedure and in the Business and Professions Code. Madam President and members, please look at the very brief 2+ pages of the bill and note that the bill amends only the Welfare and Institutions Code. It does not amend, add to, or subtract from MICRA. Again, the bill does not amend, add to, or subtract from MICRA. In order to do that, it would have to amend relevant code sections. It does not. So that issue should be a non-starter and off the table for our conversation today. Second, I should point out that we've already taken this step with respect to elder financial abuse. I authored legislation in 2004 that said preponderance would be the standard of proof for elder financial abuse. And we heard the same criticisms then and the same projections about all the bad things that would happen. And here we are 7 years later, and those bad things haven't happened. What has happened is that it's easier to hold people accountable when they take advantage of a vulnerable population. Is this an unusually low standard of proof? No, it is not. It not only applies to elder financial abuse, it frankly applies in most other similar kinds of cases, including medical malpractice and wrongful death suits. If anybody is entitled to this standard of proof and to this measure of protection, it is a population that is by its definition most vulnerable in a set of circumstances where it is by definition most difficult to make the case. If we want to provide a deterrent and we want to provide some modicum of justice, please vote aye.
Secretary will call the roll.
Alquist? Aye. Anderson? No. Berryhill? No. Blakesley? No. Calderon? Aye. Canella? No. Corbett? Aye. Correa? De Leon? Aye. DeSaulnier? Aye. Dutton? No. Emerson? Evans? Aye. Fuller? No. Gaines? No. Hancock? Aye. Harmon? No. Hernandez? Huff? No. Kehoe?
Aye.
Aye. Lamalfa? No. Leno? Aye. Ted Lieu? Aye. Carol Lieu? Aye. Lowenthal? Aye. Negrete McLeod? Padilla? Pavley? Aye. Price? Aye. Rubio? Runner? No. Smidian? Aye. Steinberg? Aye. Strickland? No. Vargas? Walters? No. Wolk? Aye. Wright? Aye. Wyland? No. Yee? Yee, aye.
Call the absent members.
Correa? Emerson? Hernandez? Negrete McLeod? Padilla? Aye. Rubio? Aye. Vargas?
Ayes 21, noes 14, measure passes. Members, we'll go to file item 151, Senator Yee's item. Secretary will read.
Senate Bill 9 by Senator Yee, enacting to sentencing.
Thank you very much, Madam President and Senators. This bill, SB 9, is a reintroduction of SB 399, which was approved by this House last year. Let me just kind of summarize the bill in general and then talk about the amendments that further restrict the ability of these young individuals to get a rehearing. This bill basically talks about youngsters who have a sentence called life without the possibility of parole. These individuals, these youngsters, did in fact commit a rather horrible crime. But this is a bill that tries to give young individuals a second chance, and that's all it does, just to give them that second chance. And they have to earn that second chance. It is not about the fact that they just simply petition the court and they're going to get a second chance. They have to petition and earn that particular right for that second hearing. And so the bill that we have right now, when I first started this particular issue a number of years ago, there were a handful of countries in this world that had this particular type of sentence. Now, the United States and California, we are the only jurisdiction, albeit that there are other jurisdictions in the United States, but this country is the only country that has this particular sentence. And literally, when we are putting youngsters in the sentence, they are sentenced to die in prison. When we first started this issue, we asked what is the total number of youngsters who have this particular sentence, and literally the Department of Prisons Corrections did not know. And the reason for that is that if they're going to die, you don't need to really worry about those individuals. They're going to die. And so what this bill will do is to give them that second chance. When we went to the Senate Appropriation Committee, there were still some concerns, and what we did was we further limit the number of hearings that these youngsters would be able to avail themselves for this second chance. And so rather than 4, we reduced it to 3. We added the additional requirements of showing remorse in addition to rehabilitations and all of those indicators that suggest that these individuals can, in fact, be rehabilitated and be productive citizens once again. So this bill is really about giving kids a second chance. It does not diminish in any way the horrible crime that was committed, but for the sake of the future of our society and also dealing with our prison overcrowding, this is really an opportunity to try and address those two issues. And with that, urge an aye vote.
Discussion, members. Senator Harmon. Senator Harmon, yes.
Thank you. Thank you very much, Madam President. I just want to remind members that the court doesn't take the decision to grant a juvenile life without parole lightly. It's not just boom, automatic. It's a major, major decision that happens in the trial court. Before a juvenile receives a life without possibility of parole sentence, the prosecutor, the district attorney, must pursue that remedy and must ask for it. You know, they don't have to do that in every case, but if they decide the case is so terrible and so bad and so aggravated, they can do it. Then the prosecutor must prove and the jury must unanimously agree that the defendant committed the murder, but he did so with special circumstances that justify this type of a punishment. And then the judge must agree that the crime was so severe that the individual did not have the right to parole at any future point in time. Now, members, we're talking about 16 and 17-year-old individuals. We're not saying young people or whatever. That's the age category we're at, that just per chance they happen to slip under the 18-year adult status. Then this bill would say, oh, well, we should feel sorry for them and we should let them out. They've been in prison for a number of years. Members, I've been in the legislature 10 years. 10 years. And when this bill came to Public Safety Committee for hearing, the widow of a slain police officer testified in probably the most emotional testimony that I've heard from a witness at a committee hearing in the 10 years I've been here. She showed us a picture, a photograph of her healthy, living husband that she had been married to for many years and what he looked like the day he walked out the door to go to work. And then she had another photograph of him after he had been beaten within an inch of his life by juveniles aged 16 and 17 years old with a lead pipe. Multiple skull fractures and broken bones, things of that nature. And unfortunately, this gentleman, I believe, if my recollection is correct, about 10 days later, passed away. There's no reason to let this killer out of jail, out of prison, for the terrible, terrible crime that he committed. And there's no reason to let other offenders that just by chance happen to just sneak under that bar of 18 years of age and let them have a second chance. They are killers. They are murderers. They have no remorse. They should be punished and left in prison for the rest of their lives. The families of these victims demand that type of justice. That's what was promised to them when the case went to trial many years ago. There's absolutely no justification for showing mercy to these types of vicious killers in these types of situations. I urge a no vote.
Senator Vargas.
Thank you very much, Madam President. I want to thank the author for bringing this bill forward. I think it's a very important bill. I agree that there are some youth that commit some crimes that are so heinous and they have such a dark soul that they shouldn't be released, that in fact they should spend the rest of their life in prison. However, this bill allows that. In fact, if there is no remorse, if the person has not tried to rehabilitate his or her life, the person does spend the rest of his or her life, in this case all his, in prison. However, I also have a 15-year-old daughter, and I can tell you when a person is 15, 16, and 17, they don't think like a grown-up. They don't have the same experience. They don't have the same facility yet. Their mind does change. Many of you met my daughter. She's a very mature girl for her age, I believe. And without saying anything here that would be too negative about my daughter, she makes some decisions that really makes me scratch my head and say, how could she have done this? She's such a bright girl. And yet she makes some decisions that are just not adult decisions because she's not an adult. As sweet, as kind, as loved as she has been, She makes mistakes. And that's what I think we're looking at here. Kids who, some of whom had made horrible mistakes. And by the way, some of them are in prison for the rest of their life, not because they committed the underlying murder. Under the felony murder rule, they're an accomplice. The person may be 19, 20, 30 years old, the person they're with, they commit the actual murder. And yet, this youngster gets the same sentence. This youngster goes to prison for the rest of his life. And that's not to take away anything from the victims. Many of us, especially those of us, I believe, who serve in very urban areas, have friends, family members who have been victims of very violent and serious crimes and even murder. And of course, those families are destroyed. And we understand that, and we feel for them, and they do deserve justice. And we try to attempt justice. But justice also means mercy. And we should show mercy to some of these kids. That's why I thank the author for bringing this forward. I hope that we can show mercy to some of these children.
Senator De Leon.
Thank you, Madam President. I, too, want to validate my good friend from San Diego, his comments, Senator Juan Vargas. I know that Mr. Vargas has always been very compassionate about this issue. I want to thank again Senator Leland Yee, because he's been very consistent right in the middle of a storm of criticism with regards to this issue. This issue is not about being soft on crime, by no stretch of the imagination, regardless of how heinous a crime that may have been committed. It's not about that. What it is specifically is gives an opportunity after 15 years for a review. Does not guarantee at all whatsoever, no form, way, or shape. Just says after 15 years, which my understanding, the difference from last year, you had 10 years. It's been increased 5 years after 15 years. Let me point something out. These young men and women, 89% of them that are incarcerated with 25 years to life are children or young teenagers of color. Roughly 49% of those individuals, 49% of those individuals were convicted under the charge of aiding and or abetting, which means specifically, as Mr. Vargas just highlighted, I know every individual in this room who has a kid and gone through those teenage years, whether you're white, brown, whether you're Asian, African American, whether you're upper class, middle class, lower socioeconomic strata, we've seen what teenagers do. We've seen what our own kids have done. And quite frankly, I will say this publicly. I don't think if you're a teenager, regardless of your socioeconomic status, regardless of your gender, regardless of your ethnicity, you're very bright. You're not very bright at that age. You do a lot of dumb things that later you regret in life. And hopefully they won't stray outside the parameters of the law that we have here in the state of California. Unfortunately, we have a handful of kids who do that. So these kids aren't thinking in their own right mind, to be quite frank. You got hormones jumping all over the place, you got irresponsibility, you got everything imaginable. But that one thing that does happen, a kid does a stupid thing and is driving a car, and his friend says, let's go up to the liquor store because we're going to try to get someone to help us buy some beer. Rolls up to the liquor store, and lo and behold, a robbery just took place, and someone just got fatally injured or harmed. There's no doubt about it. There are consequences to be paid. That's the law of the state of California. We get that, and we understand that, and we respect that, and we recognize that. But when you have a kid who unknowingly aided and abetted by driving a car and automatically gets 25 years to life, he has no access to legal counsel, and he can't even get a hearing because we want to create the facade, the smoke and mirror that we're the toughest in the entire world when it comes to crime. It's nonsensical, it's illogical, and quite frankly, economically speaking, due to the budget crisis, it makes no sense. This is about giving these kids a hearing and a review. Again, underscore, highlight, it is not a guarantee, no form, way, or shape. But we're the only nation in the world, if I'm correct, and I'll be more than happy to be corrected if need be so, we're the only nation in the world that does 25 years to life to young children. So therefore, I want to commend Senator Leland Yee for having the courage to stand forward to give these kids a second chance. Thank you, Madam President.
Senator Anderson.
Of course, I want to give those kids another chance, too. I'd like to give those kids another chance. It was said that by one of our colleagues that they don't think like adults. I think that we've read in the paper before that some of the members in the legislature don't think like adults. I don't think that's an excuse for poor behavior or criminal behavior. You know, my concern's about the families of the victims, the people who love the victims. And, you know, we're looking at a process where, because of the financials of the state, we passed a bill to early release some criminals. And if we do this, the pressures on the criminal system, in the justice system, will be to early release a lot of these folks as well, perhaps before they're ready to be released. I want to have compassion, but I want to have compassion for the victims' loved ones. Every 15 years, they have to relive what they went through. If you were in public safety, like Senator Harman and I were, and listened to what that family went through, 52 hits to the head, 6 of them had knocked out the officer, 52 hits total, brain, skull fragments flying in the air, caught one of the perpetrators in the chin as he was wailing on his head. He would be eligible for this. I'm sorry. We can do better. I get that we want compassion, and I get that we want to do it, but I think it's ill-placed. It should be placed with the families of the victims. It should be placed on the future of allowing these kids out, these psychopaths, out to harm again. Now, I want to have that compassion for them. I think the fact that we're not executing them is showing a lot of compassion, because in many of these cases, I would support executing the psychopaths. Let's send a clear message to the kids who are on the fence, the kids who are thinking, can I be stupid on Saturday night and not be caught up? Let's send a clear message to those kids that crime doesn't pay, that there's consequences for these behaviors. If we turn around and say, well, we're going to early release and take a second look at this stuff and go be overly compassionate, we're not sending the right message to our children. That's just not acceptable, not for anyone. Let's show respect for the victims today, and let's vote no. Thank you.
Senator Cannella.
Yes, thank you, Madam President. I rise in strong opposition to SB 9 as well. I think there's a lot of discussion about children and youngsters, but the reality is these are bad individuals that have done very bad things. And I think we should have a little more compassion for the victims and the families of the victims rather than the ones that committed the crime. And also, we have district attorneys who have the ability to look at the various charges. I don't think the DAs are in a hurry to charge these individuals that commit these crimes with something that is larger than the crime itself. And so I trust the DA's judgment. And furthermore, I trust the judges, once they're handing out the sentences, I think that they will be fair as well. So I think this goes in the wrong direction, and I urge a no vote.
Further discussion, members? Seeing none, Senator Yee, you may close.
Thank you very much, Madam President. I want to respond to, I think, the opposition. There have been a number of comments about the fact that these youngsters, ought not to be released, and that this bill would, in fact, release them, and that's furthest from the truth. All this bill does is to give youngsters the opportunity to petition the court for a possible rehearing, and that's only after 15 years. After 15 years, you have to then demonstrate that you are worthy of that particular consideration. And even then, the sentence that you have, an LWOP, is then converted to 25 years to life. And so there's still no guarantee that you're going to get out of prison. After 25 years, then you have to petition again to ask whether or not I am deserving of parole. And so this is not about get out the jail free card. This is really about asking the courts to re-examine. Now, I think that there are a number of comments about, well, you know, all these youngsters committing all these horrible, horrible acts that show no remorse. Well, if they're not showing remorse, then they would not qualify. And if they are, in fact, a psychopath, they would not qualify. So none of the cases that you are talking about would ever end up getting a hearing whatsoever. And let me just say that there have been other cases. And let me give you one case. There was a youngster. There was a youngster who was an accomplice to a murder. Didn't pull the trigger, but he was an accomplice to the murder. When he got caught, the DA basically said, you got to plead guilty. And this kid basically said, why would I plead guilty if I didn't pull the trigger? You know, I had nothing to do with the killing. I may have driven the car. I may have been next to that person, but I didn't pull the trigger. The DA says, well, if you're not going to plead guilty, then I am going to, in fact, send you to the prison for the rest of your life, and you're going to die. And the kid basically said, why would I have to do that if I didn't commit the murder? That is the thinking that kids have. They are what we call in psychology, they're concrete thinkers. Either I did it or I did not do it. They don't understand the vagaries and the various interpretation of the law. Either I shot that individual or I did not. Either I hit that individual with a hammer or I did not. And I didn't do either. And so why would I plead guilty to a murder? And the DA basically said, well, if you're not going to somehow demonstrate that you have admitted the crime, then I'm going to throw the book at you. And that youngster is now in prison for the rest of his life without the possibility of parole. And the U.S. Supreme Court has already opined on that particular matter that says that because of the maturity of individuals or the lack of maturity of individuals, their adolescence, particularly because of their brain development, the Supreme Court have said you cannot measure children with adults, and therefore you cannot sentence a child to a capital punishment because there are differences in maturation, brain development, and on and on. So if we are now accepting a rule of law that you cannot sentence kids to capital punishment because of the lack of maturity, lack of brain development, then why don't we use that same criteria in these particular situations? And that's all we're saying, that because of the lack of maturity, the lack of brain development, these youngsters don't understand some of the things that we understand. And as a result, they made a horrible mistake. And again, we're not saying let's let them out and let them commit again and again and again. We're saying that if those individuals have accepted responsibility, demonstrated rehabilitation, accepted the fact that they did something horrible and so on, and that they have indicated that they're not going to be doing it again, that there's a high chance of not doing it again, then we are asking the courts to say, give them a second chance. And that's all. And if they don't measure up, the courts are going to say, forget it. And they don't, guess what? They only have 3 chances. They only have 3 chances to go back to the court and try to convince the court that they are deserving. And you know, and I know that if you're going to not change your history and you change your background and change your rehabilitation program, you're probably not going to be that successful. So you're going to be earnest about it. You're going to be earnest about changing your way. Because guess what? If you don't do that, you're going to die in prison. And so this measure is going to help us, help a lot of these youngsters turn their lives around. How many kids are we going to waste in our prison? How many kids are we going to waste in society and just simply say, well, I guess if you've done something wrong, we're going to throw away the key and you just die and lay away. And that's not, I think, the compassionate state that I have lived in. That's not compassionate society that I understand. And again, I'm not taking away anything about the horrible things that happened to the victims. But all I'm saying is that while we care about the victim, we ought to at least care a little bit about those individuals who committed these crimes, because after all, they are my kids, they're your kids, they're our daughters, your daughters, they're our children. And with that, urge an aye vote.
Secretary will call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. No. Corbett. Aye. Correa. De Leon. Aye. DeSaulnier. Dutton. No. Emerson. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe.
Aye.
Aye. Lamalfa. No. Leno. Aye. Tedlu. No. Carol Liu. Aye. Lowenthal. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Runner. No. Smidian. Aye. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. No. Wolk. Wright. Aye. Wyland. No. Yee. Yee, aye.
Call the absent members.
Correa. No. DeSaulnier. Aye. Emerson. Lowenthal. Rubio. Wolk.
Senator Yee moves a call.
Lowenthal. Aye.
Just one moment. The bill's on call. Senator Yee, do you want to lift the call? We'll lift the call and call the absent members.
Emerson. Rubio. Wolk. Lowenthal's aye.
That is ayes 21, noes 16. The measure passes. Members, as I said earlier, we will recess now to take up Rules Committee and Judiciary. We'll come back to the floor around 2:45. We're in recess.